डॉक्टर बाबासाहेब आंबेडकर ओपन युनिव्हर्सिटी.
Hello friends, good day. A warm welcome into the Chaitanya studio of Dr. Babasaheb Ambedkar Open University. I, Dr. Ajay Patel, I am going to discuss the cybercrime related topics, and I would like to continue the discussion of previous session. In previous session, we discussed regarding the some important sections of Indian IT Act, or we can say the Cyber Law of India. So these are the if we continue our discussion, so these are the section, because in previous session we discussed about the section 66 and A, B, C, etc., section 69. Now section 68. As we discussed, according to the law, government has established certifying authority as well as controlling authority. The controlling authority has been assigned various powers, or to deal in terms of cyber security or in terms of cyber law. The government empower the controller authority or certifying authority. So of course the controller authority is responsible to address or to maintain the to resolve the conflict between the parties. Apart from that, they are also responsible to maintain or to keep watching on the organization in terms of whether they are maintaining the government guideline to mitigate the probable risk which would arise due to the violation of standard policy or the SOPs derived by the government in terms of cyber security policy. So in section 68, it is derived that the failure or refusal to comply the orders. Now that means if any person or any organization who is responsible to maintain the user's activity log, or who had been asked to provide it the decrypted data of the encryption, or the, we can say, parties are responsible to comply the government orders, and they are supposed to provide the data on demand basis by the government agencies. But if they fail, at that time the penalty clause are there in a IT Act 2000 under the section 68, and the section 68 says that, or focuses, we can say, if the agency fail or particular organization fails to provide the data, then this kind of organization is responsible, means the authority or the responsible persons from the organization are liable to punishment for the 3 years imprisonment as well as the fine up to the 2 lakh rupees. Now the section next, we can see the section 69. Now it's about to failure or refusal to decrypt the data, and this is the classic example, because certain organization or certain software provider or hardware providers are claiming that they are providing decryption end-to-end decryption. That means it is not possible for them to provide the encrypted data. And the classic example is the Information Technology Ministry's recent clash with the WhatsApp regarding the fake news uh, circulation and origination. So, as we know, if we look into the detail, as we know, the fake news, it's a burning issue. Means we can say the person or as we know, the fake news are spreading rapidly, and sometimes it is very difficult for the government agency to handle the situation which arise after the fake news circulation. The situations are like public protest or communal tension between in society. So such kind of, or we can say some local business spread news, also spread some hater in a society. In that case, the government agencies are uh, facing so many challenges to handle this kind of situation, because the WhatsApp circulation, as we know, within few minutes we can send, or anyone can send fake news to thousands of peoples. And if we are using the WhatsApp group, then within a minute anyone can send the same message to million of people. Now, at that time, what happened? The agencies are not able, or in other words, it is very difficult for the agencies to deal with this kind of situation. So, the IT Ministry of India had asked to WhatsApp authorities to provide the messages, particular messages or monitored messages, and they also asked to provide the complete track, originating track, means who is the originator of the message, which kind of message he had sent, then after to whom he had sent. So these kind of information are required, and Government of India Information Technology Department asked to the social media authorities to provide this kind of information. But the WhatsApp claim that they are providing end-to-end encryption. So they are not able to provide the decrypted message. So in that case, government insisted WhatsApp to provide the decrypted message, because it's in a benefit of interest. That means we can say it might affect the sovereignty of or integrity of the country, security of the state, and in certain cases or matters, it also affects the friendly relation with foreign state. So in that case, if any agency denies to providing this kind of data, then under section 69 of Indian IT Act, he is liable for the imprisonment up to the 7 years and possible fine. Now, if the next section, so next section is like that. Securing access or attempting to secure access to protected data. So, the appropriate government may, by notification in official gazette, declare that any computer system, computer network to be protected system. And these kind of systems, these kind of notified systems can hold the sensitive data, or it is quite natural then this kind of important system can be classified as a protected system by the Gazette of Government of India. Now, by order in returning, authorize the person who are authorized to access the protected system. So, for example, government is also provide specific kind of mechanism or specific orders. Government also issues the order, and it clearly mentioned that who are the authorized person to access this kind of systems. Now, if the person who is unauthorized, who is not authorized to access this kind of system, is found to access or is trying to access this kind of system, is found to trying to access this kind of system, then he is liable for the imprisonment up to the 10 years with and or with a fine. Then after another section or important section is section 67. Now it is related with the misinterpretation. Now misinterpretation, that means to suppress the fact, to mislead the data, or mislead the authority with the some artifact or manipulated data. In that case, we can say if anyone makes any misinterpretation to or suppress any material fact from the controller or certifying authority for obtaining any license or digital signature, in that case the government says he is liable for the prison up to the 10 years and or with the fine. So friend, these are the importance sections which are required to learn, and as a cyber security professional, because there are several incidents like person A is copying data from the person B machine via pen drive, but at that time you need to understand that according to the Indian IT Act, it is a crime and it is a punishable crime. You cannot forward any email from your official email ID for the organization you are working. You cannot forward any mail from your official ID to your personal ID without the authorized permission. Without the authority's permission, that means you need to get approval from the authorized person before you are forwarding a mail from your official email ID or official email ID's mail inbox to your personal mail ID. You cannot access any resources of your organization. Even if you cannot hold any access right of your older organization for which you previously worked. Now, if you are the ex-employee, then you have to, if you are the ex-employee of particular X organization, then it is your responsibility to inform your authority of the X organization to remove all the access rights which had been issued on your account. So these are the simple understanding for the sections which are available under the Indian IT Act. So, in any cases, we should keep in mind these facts, and we should avoid each and every activity on a cyberspace which leads us towards the cyber act violation or for the cyber criminal activity. Now, then after the most interesting aspect, electronic evidence or digital evidence. So, if we look or we discuss the Indian Evidence Act, or if we discuss the judicial process of India, the systematic judicial process was in existence since the Mughal Empire. In India, the systematic judicial procedure is in existence since the Mughal Empire, and the Indian Evidence Act, evidence, that means the proof which are required to prove the crime. The evidence, Indian Evidence Act was in exist from the 1835. Indian Evidence Act was in existence, is in existence since 1835. So later on, while at that time there was no provision for the obviously digital data, because in 1835 we could not imagine regarding the digital evidences. But while the Indian IT Act enacted, or we can say the cyber law was applied or was come into existence, at that time there are certain provisions in Indian IT Act to deal with the electronic evidence, or to deal there are certain guidelines are mentioned into Indian IT Act to how to handle the digital evidence. Now digital evidence, that means there are various form of electronic or digital evidences, and they are increasingly being used in a judicial proceedings. So the various categories of the electronic evidence, such as CD, DVD, hard disk, memory card data, website data, social network communication, email, chat messages, short SMS, multimedia messages, computer generated document, which poses unique problem and challenges for the proper authentication and subject to different set of views. Now, for example, just understand, nowadays we are buying the insurance plan online. Now what will happen? In earlier days, when anyone bought the insurance, at that time the insurance company issued policy to the insurer, means the person who bought the insurance, and the hard copy was there. But nowadays we are buying the policies online. Now what happened? The insurance companies issue online policy, that means in form of PDF document, the PDF document which with the digital signature of the authorized person. Nowadays the policy are in form of a digital document with the digital signature of authorized person. But the main challenge is that once the clash, in a possible clash between the party and insurance organization, if the insurance organization denies if the insurance organization denies regarding the purchase of policy, that means they say that like this is not a policy or this is not a valid policy. In that case, how to prove that the policy is genuine and the digital signature is also genuine? So these are the challenges. We can say these are the challenges for the court to verify the genuinity of the digital document or electronic evidence. So the concept is chain of custody. Chain of custody, that means nothing but chronological documentation of electronic evidence. So first, because nowadays what happened, it is quite common that police people find some digital evidence on a crime scene. For example, any crime, we can say crime which we can say murder. Any person murder another person, and it is clearly mentioned that the robe, or we can say the knife, was used as a weapon to commit the murder, to commit this crime. But the crime scene at where the actual crime was happened, at that time the police found CCTV camera, video surveillance system has been installed by the nearby shop owners. Means there are several shops, those who have installed CCTV camera in their premises, and the police can find police found some CCTV footages which could help to prove the crime. Now, at that time, what happened? Police cannot download the footages directly and randomly produce all those CCTV footages into the court, and based on these footages, judge issued the judgment. No, it's not like that. For that, you need to handle all the evidences properly. At that time, you need to keep in mind that you have to follow all the procedure. You have to comply all the procedure. Then after, court will consider these proofs or these digital proofs are as admissible proof in a court. Otherwise, court might challenge and ruled inadmissible proofs. So you need to perform specific procedure to collect the proofs, to collect the digital evidence, to maintain the digital evidence, and to produce all these evidence into the court. By following the right procedure only, the court will accept these proofs for the further prosecution. So the concept is called the chain of custody. Now, while the chain of custody comes into the picture, it is very important. The role of the examiner is very important. That means we can say it is very important how to collect the evidence, or to how to handle all these evidences. So that means, suppose that as the examiner, you obtain the metadata for the piece of evidence. However, you are unable to extract meaningful information from it. The fact that there is no meaningful information within the metadata does not mean that the evidence is insufficient. The chain of custody in this case helps show where the possible evidence might lie, where it came from, who created it, and the type of equipment that was used. All these kind of information need to collect and maintain while you are dealing or while you are handling the digital evidences. That way, if you want to create an exemplar, uh, you can get the equipment, create exemplar and compare it to the evidence to confirm the evidence properties. So this is the concept of chain of custody, and it is uh, very important for the examiner. Now, uh, there are certain consideration for the court also, means these are the facts which need to be considered by the court while they are dealing with the digital evidence. So first of all, it is possible to have evidence presented in court dismissed if there is a missing link in a chain of custody. That means if court feels at any point of time during the prosecution that the digital evidence are not handled properly, that times court will dismiss or court will rule that these digital evidence are not admissible in the court for the particular case prosecution. Because if court finds any missing link in chain of custody, in that case court will not accept this kind of proof. If it is therefore important to ensure that a wholesome and meaningful chain of custody is presented along with the evidence of the court. Now, so friend, this is the chain of custody, and we can sum up like the chain of custody is nothing but the way or the guideline to handle the digital evidence for the investigating person. The person who is investigating crime needs to follow the guideline in form of chain of custody. Then after, it is also mentioned for the court in terms of how to deal with this kind of digital evidence and how to verify the authenticity of these digital evidences. So this is the concept of chain of custody, as well as we also discussed some important section of the Indian IT Act 2000. In a next section, we will continue our discussion in terms of intellectual property right and in terms of copyright. Okay, friend? Okay, thank you very much.
स्वाध्यायः